A Florida woman is behind bars facing second-degree murder charges in connection to the death of her 6-year-old son. Authorities say the child was found inside the family's home during a welfare check and had likely been dead for several weeks. Investigators believe his death was the result of an exorcism-like ritual. I'm your host, Kennedi Walker, and I'll walk you through this disturbing story. You're watching Law and Crime.
She believes she was being told by God to basically exorcise demons out of the child's body.
31-year-old Rhonda Paulynice has been arrested and charged with killing her 6-year-old son, Pierre.
During the course of the interviews, our detectives learned that the mother last spoke to the child on May 18th. That's when we believed the homicide occurred.
The sheriff says Ramil hadn't been to school in weeks. A resource deputy contacted law enforcement asking them to check on the boy.
She took him inside and directed him to the bedroom where the deputy found the child deceased and laying in bed.
Authorities say it's unclear how the boy died, but Paulynice told investigators she was working with God, removing demons from his body.
When the child had stopped moving and basically passed away, at that point she felt the child had been released of those demons and was waiting for him to basically come back.
Paulynice made her first court appearance where she was denied bail.
I'm not sure who I want to appoint.
A judge assigned her a public defender. The sheriff said during questioning, Paulynice shifted between laughing and crying, describing her as pure evil.
Being a parent, being out at a scene like that, seeing a 6-year-old child that was killed for no other reasons other than just someone being purely evil.
And joining me to talk more about this is criminal defense attorney Kesia Early. Kesia, thank you so much for joining me today.
Thanks for having me.
So let's just jump right in. The suspect is charged with second-degree murder. Why not first degree? Is that something prosecutors could upgrade later?
Absolutely, they can upgrade it up until the time of trial prior to the jury being selected. And there's many factors that go into the prosecutor's determination as to whether or not this would be a first-degree murder or second-degree murder. They have to determine whether or not this was a depraved mind and whether there was a thought and whether this was planned out. And in this case, you can tell from the evidence that we know so far, the body cam footage, her temporary psychotic state, that maybe this was not well executed or well planned out on her part, but there was some intent to do harm to this 6-year-old boy, which was her son.
We keep hearing, she said, God told her to do this. How does that impact her criminal responsibility? And is claiming a religious motive the same thing as claiming insanity?
No, but there are several components. First and foremost, as a defense attorney, the first thing you want to do, if you have her as a defendant, is to get her evaluated, just initially to see if she's even competent to stand trial. And that competency evaluation includes making sure she knows what the charges are, who her attorney is, and what are the roles of the court, the judge and the prosecutor, and various factors that go on from the discovery phase all the way up to reaching a verdict. So once you make a determination as to whether or not she is incompetent or competent to proceed, having a religious or extreme religious belief in and of itself, it's not a defense, but it is a consideration as to the mental mindset that she was in throughout her time of trying to, quote, exorcise these demons out of her 6-year-old child. So all of that could possibly be justification or a possible defense that the defense team will raise on her behalf.
Look, I know I say this all the time, but truly covering these stories day in and day out, you realize things are a bit crazy out there. That's why I am so excited to tell you about a product we at Law & Crime created, the Law & Crime Safety Bracelet. This is a bracelet you can wear around your wrist or keep in your car or in your purse, and it includes multiple items that give you actual peace of mind. I'll show you what I mean. A whistle, which has a classic high pitch, great for drawing attention when it matters most. A compact flashlight that can be used to guide you in the dark or signal for assistance. A seatbelt cutter you can use in case of a car emergency, and a handy utility knife for multiple uses. And these are just to name a few. So right now you can go to truecrimegoods.com and use promo code SAFETY15 for 15% off. That's promo code SAFETY15 for 15% off. Order your safety bracelet now and carry confidence everywhere you go. And she reportedly laughed and cried during her interviews as well. I know we're like how you mentioned, just trying to figure out her mental state. Could that behavior be used as evidence towards that?
A whole host of behavior, starting from the body cam footage. When she was approached, she was nonchalant. She's putting on lip gloss. She's going through her phone in an attempt to find her identification because she didn't have the actual identification. She never attempted to hide the decomposing body that was in her home. But at the same time, prosecutors can still use the fact that when law enforcement basically informed her that they were there for a wellness check, she basically said, yeah, he's fine. He's going to come back to school later, knowing that his decomposing body was in the house. Whether or not she believed that he would have woken up from her attempt to exorcise this demon out of her child, there were attempts to kind of evade the questions of law enforcement. So there is a question of whether or not she knew what she was doing at the moment, and whether or not she came out of that temporary psychosis and was basically trying to evade law enforcement or steer them down a different path.
If she is found mentally incompetent, what happens next? Because I know a lot of people get confused when they hear, pleading insanity. If you could just walk us through the process, who requests that? Is it the defense, the prosecution? Do they request an evaluation? What does the evaluation entail? And what happens if she is found incompetent?
Well, typically anyone can request it. The judge can request it based on the behavior of the defendant in court. The prosecutor can request it, but normally the defense attorney has the most conversations with the defendant. And in this case, the defense attorney will see that there's some red flags, that there should be or could be some competency issues. So a request is made to the court. It's typically granted, and doctors are appointed to evaluate the defendant. Now, once that report comes back as incompetent to proceed, then there's a host of things that can be done. The defense attorney can request that the defendant is placed in either inpatient or outpatient treatment, whether it's drug abuse coupled with some mental psychosis, so that that defendant can be not only treated, but their competency can be restored. Now, if their competency is not restored or is not restorable, depending on the severity of the crime, and after a certain amount of time, the case can possibly be dismissed. But there's also times where the defendant can be committed into a mental facility until they have either their competency has been restored, or if not, they remain in that mental facility if they are not restorable.
Now, if the competency hypothetically is restored, but how do you find out that basically, I'm just trying to ask if the competency is restored, but it wasn't when the act allegedly happened, how do they
Yes.
go about charging her?
That's a great question. And the way it works is the charges are still going forward, right? There's just a stay of the proceedings. You cannot move forward with litigation because right now there's a temporary status of the defendant being incompetent to proceed. So what happens is every 6 months, there are, or prior to any hearings, there's competency evaluations, there's status checks just to make sure the defendant is taking their medication, because the purpose of the competency evaluation is to find out what the problem is and then restore, whether it is detox from drugs in a safe environment, and that it's usually in inpatient drug treatment centers. And then also to make sure that the defendant is taking their medication as prescribed. And then over time, if the defendant is educated, their competency can be restored. And that is when the proceedings continue, like depositions and motions to suppress or anything that requires the defendant's testimony. But until then, the proceedings are at a standstill.
Now, if we could go back to how police found the child, a welfare check was requested from the school. The child hadn't been to school in about 2 weeks, before a report was made. In your experience, how often do these kinds of tragedies happen after missed warning signs from institutions like schools or neighbors?
Yeah, it's unfortunate. And I do believe that in this instance, there was a red flag after the 5 consecutive unexcused absences. So, after this alleged murder, mom never called and excused the absences. So, when you have the first five, it triggers a red flag for the teacher. And in this case, the homeroom teacher to contact the counselor and let them know, hey, this child is missing, let's find out what's going on. And then there's a process after that. So by the time that process was completed, you had reached the 10 days, which was the 2 consecutive weeks within a 90-day period of unexcused absences, which triggered not only Department of Children and Family, but law enforcement to come and do a welfare check just to make sure the child was okay. And oftentimes it's not bad in this case, which was extreme, but there could be custody disputes where a parent did not return the child, but oftentimes the other parent will call the school. So I'm glad that there was some protocol in place and it was followed, because we don't know how long this could have happened. Yes, it was 10 days and it gave her enough time to possibly hide the body, but we're grateful that she didn't, because we know that she was fully culpable based on the evidence that we have thus far. But we also know that the defendant is considered innocent until proven guilty.
Given that the school did wait longer than usual, waiting 10 days, could the school or even any other adults in the boy's life, maybe the child's father, face any kind of liability or scrutiny, at least in the investigation?
I mean, of course, it's a possibility. We don't know about the father. We don't know if he was an absentee father and did not have any communication with the child. We don't know if the proper protocols were followed in the school. Of course, there will be an investigation done. If the child's mother should have been alerted sooner and that was not done, I'm pretty sure that there will be some form of reprimand for the school district, because, it took 10 days in this case. But again, even if they followed up after 3 days, he was already gone. So again, this is unfortunate because there was reports that this child was a regular active child. There were no history. There's no history of disciplinary action at the school. Just a very loving, angelic human being that died from the hands of his mother.
Right. Just a really horrible story. And just reports also say there were no other signs of abuse as well. Reports saying that they looked inside of the pantry and the cabinets and the house was filled with food. So just a really confusing and sad story all the way around. But let's talk about this idea of exorcism. Does the law treat that any differently than any other forms of abuse or violence?
Not at all. I mean, in fact, having a strongly held religious belief or extreme religious belief is never justification for any crime. It's never a reason or a way that you can get out of a crime because you thought you heard voices or you thought that you were being led by God. Your mistaken belief is not justifiable. But of course, she is entitled to a defense. And again, we don't know what that defense is. If she is determined to be competent to proceed, then there may be a separate defense of not having the requisite mental capacity at the time, or she did not appreciate her actions at the time. But again, you just can't claim a mental defect caused you to commit this crime. There must be a history of mental illness. There must be a history to show that you had these psychotic voices in your head well before you committed this act. So unless she can show this history of mental defect or mental illness, just claiming it on the day of trial is a weak excuse. And it's unfortunate because it's it's not it's frowned upon when you just say, "Oh, I had a mental defect, which is why I committed this murder," because you have hundreds of thousands of people suffering from a mental illness, and a mental illness does not give you the ability to use it as a fallback defense, because it just sheds this negative light on people who are suffering truly from this mental illness that needs help via medication.
Yeah, I am just very interested to see how an attorney even begins to defend her, especially if she is found competent to stand trial. Could her defense maybe try to argue that this was a religious ritual gone wrong rather than intentional harm? And even if someone deeply believes they're doing the right thing spiritually, does the court care? Because I don't think so.
Well, the only way the court's consideration comes into play is, hypothetically speaking, if she's found guilty of this heinous crime, then she's going to be sentenced. And based on that sentencing, there's typically mitigating factors and aggravating factors that will determine how long the judge will sentence her. And typically, for mitigation factors that the judge may consider is whether or not she had a lengthy criminal history or no criminal history at all, and whether this was her first run-in with the law. Has she been a productive member of society? She was 41 years old. Has she did anything that would show the court that she is possibly granted a lighter sentence versus aggravating factors that the prosecution tends to present to the court? There were reports prior to this heinous crime that her sister, which would have been the little boy's aunt, was living in a home. So there were calls of domestic violence, and the sister eventually moved out. Again, the little boy was not involved, but was she the aggressor? I'm pretty sure police reports were taken. So all of these mitigating and aggravating factors will come into play if, of course, she's found guilty. But then again, there's also plea negotiations. Sometimes the prosecutor will offer a plea deal, and she may take it, and this case is resolved without a jury trial.
She reportedly told police that she was waiting on the little boy to come back. Could that also play out in court as well? Could that also help her case? Maybe the defense could argue diminished capacity, not insanity, but that she didn't fully understand what she was doing since she thought he would come back.
Of course, and again, it goes back to her actions before and after the alleged incident. Remember, this is 10 days in the making. She had every opportunity to, dispose of his body, clean up the crime scene, and she didn't do that. So typically, when you see people with a diminished capacity or some type of mental illness that was triggered, probably because they didn't take their medication as prescribed, they don't do things that a rational person would do in the same circumstance, because you would think you had all of this time. You're in a home with a decomposing body, the smell, and did you really believe that he would come back? So there could be a possibility that she believed it. But again, these are not sole, airtight defenses. This is what the defense can present, hoping for, let's say, lesser included. But at the end of the day, there's so many factors. The evidence is overwhelming. This is a sad case. It's unfortunate that we're focusing on mom and not this 6-year-old angel that died at the hands of his mother, who was in a capacity, or should have been in a capacity, to care and nurture for him. And unfortunately, she ended his life based on these extreme religious beliefs.
Absolutely. And online, people are saying great things about the little boy. I know you mentioned it a little bit earlier, but that he was just a great kid, never gave anyone any types of problems. And he was a very, very cute and handsome little boy as well. So it's just so sad that this has occurred. But speaking of what you mentioned about just her being there with his body for a couple of weeks, what kind of challenges does that create for the investigation? The fact that, just the decomposition.
Yeah, well, typically when you are investigating a case, as the body is the decomposition sets in place, you're losing evidence. But in this case, we know that she told law enforcement how she basically murdered her child. She suffocated him, and as he was fighting for his life, he was kicking. In her head, she's thinking, "Okay, I'm getting the demons out," but he was fighting for his life. And at least they know, the way or how the child died, and they can use this to prosecute the case and complete their investigation for law enforcement. But again, it's you're losing valuable evidence as time goes by. But in this case, she made some post Miranda statements, or she made some statements not knowing that the body cam footage was on, that was helpful to the investigation.
Yeah, I was just about to ask, is there a risk that her statements to police could be thrown out if they weren't obtained properly?
Oh, absolutely. But in this case, having body cam footage, your Miranda rights are read to you if law enforcement is questioning you to obtain incriminating information. But in this case, law enforcement didn't know of the crime. This was a standard wellness check. At that point, they did not know. So they weren't asking about the crime itself. They would just come and letting her know, listen, we want to check on the child. We've received reports from the school and DCF that the child has been missing for 2 weeks. Can we come in? Well, guess what? In this case, the mom said yes. She allowed them to come in. So there's no Fourth Amendment violation. No search warrant was required. They asked and she granted access. And again, that goes back to her state of mind. Why would you grant access knowing that your child is in the home? He's dead. I'm pretty sure the odor of the decomposition hit them as soon as they entered the home, and it just showed her mindset. Unless she thought, you know what, I have no way out of this, go ahead and see what I did. We really don't know what went into her mind. And unfortunately, that would be the job of the defense attorney, is to shed light if this case goes to trial.
If this case does go to trial, how do you even find a jury for a case this just emotionally disturbing?
I've tried over 100 trials, and I always say jury selection is the most important part of trial. The first thing you want to do is make sure you choose a jury that's right for this particular trial. There's various types of trials. You have the civil, you have the criminal, and in this case, you're dealing with a 6-year-old baby, and you want to just say some of the facts up front. Of course, we can't say everything. We can't try the case to the jury, but you can, as a defense attorney, is to give your theory of defense and ask the potential jurors, will they be willing to fairly listen to your theory of defense, be fair and impartial? And if you cannot, please raise your hand. The process of the jury is to seek the truth. And we want to make sure that the jury is honest. And if this is not the case for them, typically they'll be honest and say, you know what, I can't do this. And eventually they're stricken for cause.
If she is convicted, what are the sentencing possibilities? Are we talking life in prison?
You're definitely talking a maximum of life in prison. But again, it depends on the mitigating factors. If she can receive less time, and that's based on whether or not there is a PSI ordered, a pre-sentence investigation. And that is when officers will do a background check and then just give their recommendation to the court. And then they will put on a presentation at sentencing. So it all depends on her history, the facts that came out during trial, and a sentence that the judge who hears the trial believes would be just in this circumstance.
Well, this is a case that we will be following closely. Casey, thank you so much for joining us today.
Thanks for having me.
Ramil was described as a child who lit the room up and was loved by everybody. Paulynice continues to be held without bond. For Law and Crime, I'm Kennedi Walker.